get started then. Thank you very much for inviting me and for giving me this opportunity to share some of the research that we do here at the European Union Intellectual Property Office on the relationship between IP rights and economic performance. And specifically, I will just start with just a bit of background. We all think that we are all modern and everything we're doing is new and so on. But when it comes to intellectual property rights, it's actually quite an old concept. And so I have here the oldest example I've been able to find, which is 2,700 years old, from Greece. Dealing with recipes, where as you can see, the ruler of a particular Greek city-state granted the cooks who invent a new dish a one-year monopoly to prepare that dish. And as it was stated, this will motivate others to work hard to compete in such inventions. So this already gives us a hint that already the ancient Greeks understood that IP rights somehow act as an economic incentive to engage in innovation and creation. We can then fast forward a couple of thousand years to 15th century Venice, which gave us what looks very much like our modern patent laws. So here we have a 10-year monopoly, or 10-year exclusive right for if you invent something new, then you're the only one who can make it for 10 years. So this is quite close to today's patent system, except for that it's 20 years nowadays. And then if we still go forward even more towards our own time, then we have the Queen Anne law from England from the early 18th century, which is considered to be really the first modern copyright law. And, well, I will not read the text to you. You can read it yourself, except for the underlying part, the encouragement of learned men to compose and write useful books. Of course, the language is a bit old-fashioned and sexist. Many women write useful books nowadays, and there are also many other forms of creation. But nevertheless, we see there, again, an understanding of the importance of economic incentives to engage in creation. And then finally, the final historical example I have is from the US Constitution, whose writers considered it intellectual property sufficiently important that they actually wrote it into the Constitution, Article 1, Section 8, which states that that Congress shall, effectively what it says is that Congress shall promulgate copyright laws and patent laws with the purpose of promoting the progress of science and useful arts. Okay, so I just have these two slides just to indicate that IP rights is not something that we have invented in the 20th century. This is something that policymakers have understood for a long time. Now, if we look at economic research, because that is, of course, the perspective from which I approach this issue, there have been two main lines of research on the relationship between IP rights and, let's say, economic performance. One very important part is the relationship between IP rights and innovation. And this is especially, this tends to be quite focused on patents, of course, because, with the idea to see what is the effect of patenting on firms' innovation. And well, we here at the EUIPO, we look at all IP rights, and so what we have done is to look at the contribution to the economy of IP rights, broadly measured, and we have done it in two ways. One can look at it from a macro or industry perspective, or one can look at it from a micro or individual company perspective. And these are the two studies that I will be presenting to you today. Okay, so the two questions that we ask is, what is the overall weight, if you will, or proportion of the sectors in the economy that use IP rights intensively being defined as above average? What is their weight in the economy? And a follow-on question is to look at, rather than looking at sectors, we look at individual companies, and we take a very large sample of companies and look at whether companies that own IP rights somehow perform better economically than companies that don't own IP rights. And when we talk about economic performance on the level of companies, then we look at jobs, job growth, wages, and profits, of course. Okay, so I will start with a macro or industry level perspective. Here we have made our office, the EUIPO, has made 2 studies which we have conducted jointly with the European Patent Office in Munich. We did the first study in 2013, and we updated it this year, earlier this year. It was published in October, and it is the 2016 updated study that I will be speaking about. And as you can see on this slide, there is a direct link to the document. So all the studies that I'm talking about here are freely available for download on the observatory website. So we basically wanted to look at, to quantify the importance to the EU economy of the sectors that make above average use of IP rights. And so the key question that we're asking specifically is how do trademarks, designs, patents, copyrights, geographical indication, and plant variety rights contribute to employment, GDP, remuneration, and external trade of the European Union. These are the 6 IP rights that we have included in the study. And this slide shows you briefly, summarizes briefly the characteristics of the IP rights. So we looked at first the 3 IP rights that are managed on an operational level by our 2 offices. So patents, which are managed by the European Patent Office, designs and trademarks, which are managed by our office. We also included copyright, geographical indications, and plant variety rights. Okay, these are the 6 IP rights that we considered, and you can see that the characteristics of the IP rights in terms of what is it that you can protect with them. And here I recognize that there is geographical variation in that respect. In particular, if we look, for example, at computer software, then as a general rule, computer software is protected by copyright in the European Union, whereas it can be protected by patent in the United States. Well, this is an EU study, so we look at things, we look at the EU 28 here, so that we look at things from a European perspective. Summarizing, of course, differences among the IP rights, but they share some features. They're typically time limited, except for geographical indications. The length of time varies, of course, from relatively short in the case of design to quite long in terms of copyright, and to indeed indefinite in the case of geographical indications. For those who are not familiar, I think everybody has some basic level of familiarity with patents, designs, trademarks, copyrights. But just to perhaps recognizing that we have a global audience here, geographical indications are an IP right that is used quite widely in Europe, and is beginning to be used outside Europe as well quite often, which simply indicates that for a certain product, we can take, for example, Parmesan cheese or feta cheese, that the quality and reputation of that product is linked to its geographical origin, meaning that it has to be made in a particular area. Sometimes that area can be an entire country, but more often it is a specific region within a country. And there's often also a specification of which ingredients may be used, which production methods can be used, and so on. It's applied mostly to foodstuffs and to wines and alcoholic drinks. Plant variety rights is similar. It's besides the the EU trademark and the EU design, this is actually the only EU-wide intellectual property rights until we get the new unified patent into force. And it protects, as the name indicated, plant variety, and it's an IP right that's heavily used by growers of, for example, flower varieties and so on. Okay, I will not dwell too much on the methodology. It is explained in full detail in the study, and that, as I said, you can download from our website. But basically, for the 3 IP rights that are managed between our office and the European Patent Office, so patents, designs, and trademarks, we looked at the companies that have registered those IP rights with our offices. We matched them to a commercial database that allowed us to assign those companies to sectors of the economy, and this in turn then allowed us to calculate how many of each of those IP rights companies from each sector had registered with us during a specific period of time. Copyright the other 3 IP rights had to be treated differently because of their peculiarities. So in the case of geographical indications and fan variety rights, we had to develop some bespoke methodologies to determine which sectors use those rights intensively. And in the case of copyright, we used a methodology that has been developed by the World Intellectual Property Organization. It's a UN body that deals with IP rights on a global basis, and they have developed a classification of copyright-intensive industries, which we have simply adopted for this study. Okay, so I now move on to sharing the results with you, and the first one is that is shown on this very confusing Venn diagram on this slide. And what does it show? It shows for each IP right how many sectors in the EU economy are intensive in their use of that IP right. Altogether, we identified 342 IP right intensive industries. And to take an example, we have, for instance, 140 patent intensive industries. But what you can also see is that for most industries, they make use of more than one of the IP rights intensively. So of the 140 patent-intensive industries, for instance, only 15 are exclusively patent-intensive. So the other 125 are also intensive in the use of at least one of the other IP rights. Often it's usually trademarks and designs, because patents, usually in Europe anyway, deal with physical products, so to which designs can also be applicable. And of course, trademarks are applicable to everything essentially, because everything can be branded and every brand can be protected by a trademark. So this is also why you can see that there are 277 trademark intensive sectors, because of what I just said. The trademark is the most widely applicable of the IP rights in terms of what it can be, what types of products and services it can be applied to. Okay, so there's a great deal of overlap, which is important to keep in mind when I present you the results on the economic contribution of the different IP right intensive sectors, because when we add up tally up a particular sector's contribution to the economy, we have to be careful that we do not double count. So we have a particular industry, such as the auto industry, for instance, that is intensive in its use of both trademarks, designs, and patents. Then we do not count the output of that industry 3 times when calculating its contribution to European GDP. We count it only once, so we eliminate double counting. So we start by looking at employment. Okay, we found that the sectors that we had defined as being intensive in their use of IP rights, that those sectors during the period 2011 to 2013 generated 28% of all employment in the European Union. Okay, and that 28%, you can see that depicted between the different IP rights. Well, sorry, I should back up a bit. So that's the 28%. This is what we call directly generated. But then in addition to that, the different sectors in the economy buy goods and services from one another to produce whatever it is that they produce. So therefore, there is some portion of employment in industries that are not themselves IP rights intensive that can be attributed to the IP rights intensive industries, because the latter buy goods and services from the former. So this is what we call an indirect effect, which accounts for another 10% of employment. So that all in all, we can say that directly or indirectly, 38% of employment in the European Union can be attributed to industries that use IP rights intensively. Now, this is not to say that those jobs would not exist without IP rights. Okay, we say nothing about cause and effect relationship here. This is simply a picture, a photograph, or a map of the economy, if you will, a description. This is a purely descriptive study. Now, if we then look at the contribution that is made by industries that are intensive in respect of each particular IP right, then we can see that trademarks account for 30.3% of employment, or trademark-intensive industries, followed by design-intensive industries with just under 18% of employment, and patent-intensive industries with 16.7%, and so on for the other IP rights. And of course, you will immediately notice that these figures add up to a lot more than 38%, but this is because of what I said before, that when we arrive at the 38%, we eliminate the double counting. Okay. So that is the contribution of those sectors to employment. We then move on to their contribution to economic output, or GDP. And again, all the figures I mentioned here on the level of the European Union, so together for the 28 member states. And we find that 42% of economic activity in the European Union was generated in those 342 IP rights intensive industries. And again, you see that 36% almost was generated in the trademark-intensive industries, 15% in the patent-intensive industries, 13% in the design-intensive industries, smaller percentages for the other IP rights. And again, as before, we eliminate the double counting, and as before, we see that trademarks are the most widely applicable IP rights, because again, I repeat, not everything can be patented, not everything can be protected by copyright, but everything can be branded, and therefore everything can potentially be protected by a trademark. Okay, so having established the proportion of jobs and the proportion of GDP that is accounted for by the IP rights intensive industry, we then looked at wages. So those industries, those sectors provide a lot of jobs, generate a lot of jobs in the EU, but do they also pay better? And the answer is yes, they do. As you can see on this chart, on average, overall, the IP rights intensive industries paid 46% more than non-IP rights intensive industries. And if you look at the individual, in terms of individual IP rights, then you can see that this wage premium, as we call it, was highest in the case of the patent-intensive industries at 69%, closely followed by the copyright-intensive industries at 64%. For methodological reasons, it was not possible to calculate it for the plant variety right-intensive industries. I should also mention that by coincidence, a very similar study was published in the United States just a month before ours in September 2016, where a similar analysis was carried out, and the result in terms of the overall wage premium was identical to ours. So it was found in the US economy, the IP rights intensive industries also paid 46% more than the non-IP rights intensive industries. And it was also the case in the US that the highest wage premium was indeed associated with the patent and copyright intensive industries. So this is very interesting and illustrates the structural similarities between the economies on both sides of the Atlantic. We've then looked at EU's external trade. And when I speak here about EU's external trade, then I refer to trade between the EU and third countries. So in other words, trade between Spain and France, for example, is not considered trade because that is trade between two EU member states. So here we're talking about trade between EU and, for example, the United States or China or any other non-EU countries. And what we find is that almost all of our external trade is in IP right intensive industry. Specifically, 86% of all imports of the European Union are in those industries, and 93% of our exports are generated in the IP rights intensive industries. The fact that most of Europe's exports are in IP rights intensive industries is not surprising to most people. The fact that the bulk of our imports is also in those industries does sometimes surprise people, because I sometimes get the reaction, yeah, but wait, the main import of Europe is oil, for example, and other raw materials. But there's, what's the IP right there? And of course, at first blush, one might think of oil as just another raw material. But when you think about it, then about the technology that goes into finding the oil, extracting it, transporting it, and then refining it, then you realize that there's, of course, a lot of science and technology that goes into this, so there's a lot of patent, and those sectors are actually also usually trademark intensive. So therefore it is maybe less surprising than at first blush that also such a high portion of EU's imports are in IP rights intensive industries. Overall, the EU had a trade deficit of 42 billion euros. This refers to the year 2013, I should add. But when we look at the IP rights intensive industries, then in fact we had a trade surplus of 96 billion in those industries. So they make a useful contribution to the EU's trade balance with the rest of the world. Okay, now, of course, no study of the EU is complete without looking at the individual member states, because this is, of course, always of great interest. So we looked at the individual, all of the 28 countries to see where was this IP right, where was the share of IP right intensive industries particularly high. So what you see on this map is the countries that are dark shade, in the darker shade, are the ones where the contribution of IP right intensive industries to employment is above the EU average of 28%. So we see that this is the case for example, if we look to the north, we see that is the case in Denmark, Sweden, and Finland, as well as Estonia, Germany as well, Austria, the Czech Republic, Slovakia, and Hungary, Italy. So these are countries that for a variety of reasons have a lot of jobs in IP right intensive industries. Now, some people might say, but wait, you know, there is not a lot of innovation or patenting that occurs, that originates in some of those countries, and that is very true. But what we're counting here are jobs in production and in research and development, of course, as well. But so in this example, for example, if a French car company builds cars in Romania, then the car industry being IP rights intensive, but the jobs in question in this example are not in France but in Romania.
Nathan, there's a question from Wolf Meyer from the World Trade Organization.
Yes.
It says, when you did the research, are the results controlled for size of the companies? For example, is it just the big companies that are IPR intensive and trade a lot or not?
Well, this analysis is not done on the level of companies, but on the level of sectors. So, so really the issue of the size of the companies is not relevant in this particular study. It is relevant in the second study that I will discuss shortly. Okay, so this is the picture for employment. If we look at the picture of in respect of economic output, then we see also that it's more or less the same countries that are above average. We still have Finland and Denmark, as we did before when we looked at employment, that are above the EU average, but now also the UK and Ireland, and as before, Germany and Italy and some of the countries to the east and south of Germany as well. Okay, in the report we have this kind of analysis also for the individual IP rights. So you have maps like this both for the trademarks, separately for trademark intensive, patent intensive, copyright intensive, and so on. But here, in the interest of time, I just show you the overall picture. We then, in the final chapter of the report, we then looked at where do the IP rights that give rise to those jobs and that economic output, where do those IP rights originate? Okay, because one, as I said before, I gave my my example with a French car company that builds cars in Romania. In this case, the production jobs are in Romania, but of course the design of the car and the development, the technological development likely is taking place somewhere else. It could be in France, it could be in a completely third country. So what we have looked at is, we looked at ours, and so the EUIPO's register, and we looked at EPO's register to see where do the patents, trademarks, and designs that are registered in our offices, where do they come from? In which countries do they originate? And this is what you see here for trademarks, first of all. So on the bar chart in the lower left corner of the slide, in the bar chart you see the absolute figures. And this is, again, this is for the period 2011 to 2013. So you see that Germany is number one, followed by the UK, Italy, Spain, and France. So not surprisingly, those are the 5 biggest countries in the EU, so they are also the ones that filed the most trademarks. And Germany, being the biggest, is number one in absolute numbers. But then on the right, you have these round circles. Each of them represents a country and is placed roughly in the location within Europe to which it corresponds. But there we relate the absolute number of trademarks filed from that country to the size of the economy as measured by the number of employees in the IP right intensive sector. So the number in each circle shows the number of trademarks filed per 1,000 employees. And there you can see that while Germany is still pretty high, setting aside Luxembourg for a moment, there are a couple of small countries, Luxembourg and Malta, that are very high on that score, and Cyprus as well. But looking at the bigger countries, we see that Germany is now not nearly as dominant as it is in absolute figures. So Germany at 0.51 trademarks per 1,000 employees is on the same level as Denmark and Sweden, similar to, slightly higher than Ireland and the Netherlands and Spain, and slightly lower than Austria. But we also see that what we usually call the new member states of the EU, which are not so new anymore since they joined in 2004 and 2007 for the most part, that they still generate only a very small, much lower numbers of trademarks per 1,000 employees than do the old EU member states. We see the same pattern for design. If we look at the registered community designs that come to the EUIPO, then again, in absolute numbers, Germany is in the lead, although now in second place we have Italy. Of course, we all know that the design is something that is very important and very treasured by Italians, and this is reflected here. But again, when we relate it to the size of the economies in terms by dividing the number of designs filed per 1,000 employees, then we see that again, Luxembourg is in first place, but Germany now is no longer in first. Germany is not in first place. Germany is in fact surpassed by several of the other countries, such as Denmark, Austria, and and again, as before, we see that the new member states file a very low number of designs. Finally, for patents, again, same picture. Dominated by Germany in absolute numbers, we are reflecting the high share of manufacturing in the German economy, followed in this case by France, the Netherlands, the UK, and Italy. So the order behind Germany is slightly different. But again, looking at it in relative terms, Germany is now below as before Luxembourg, but also is now on the same level as Denmark, the Netherlands, indeed slightly below Sweden and Finland. Okay, so looking at it relatively gives a different picture than looking at it in absolute terms. But again, as before, the new member states, the eastern and southern countries, are well below the EU average, whether you look at it in absolute or relative terms. Okay, I will skip, I think, the plant varieties and go to this slide, which shows this pattern of job citing within the European Union that I referred to before. So I keep coming back to my example of French companies, car companies building cars in Romania, or German companies building cars in the Czech Republic, and so on. What we see on this chart is the proportion of jobs in IP right intensive industries in each country of the European Union that are created by companies from other countries. Okay, so if we look at the country on top, which is Hungary, then we see that something like 38% of all jobs in the IP right intensive industries in Hungary are created by companies from other countries. And the dark part of the bar indicates the percentage created by companies from other EU member states. Okay, so in the case of Hungary, something like 24% of the jobs are created by companies from one of the other 27 EU member states, and a further 16% or so are created by companies from outside the EU altogether. And so you can see at the top of the list you have several Eastern European countries, Hungary, Romania, the Czech Republic, we have Slovakia in there also, Estonia, Ireland is also in there. I notice one thing worth noticing is that Ireland and the UK are the only two countries on the list where the percentage of jobs created by non-EU companies is higher than the percentage of jobs created by other EU companies. Okay, so this was the macro or industry perspective. Okay, then but that of course does not tell the whole story, because within a particular sector of the economy, it could be that there are some companies that are intensive in their use of IP rights, that own a lot of trademarks or patents or designs, while other companies, even if the sector as such is intensive in that IP rights, does not mean that every company within the sector is intensive in the use of those IP rights. So it is therefore also important to look at the level of individual companies, and this is what we did in a study that we published last year, which is again also available on the website of the EUIPO, on the link indicated here, where we looked at a very large sample of the study. So the difference between the two studies is illustrated in this chart, where the industry level study that I just discussed looked at the contribution to GDP, employment, wages, trade, etc. of the sectors that make intensive use of IP rights. But in the firm level study, as the name indicated, we look at the firm level, so we try to see if there is a relationship, a correlation between the use or ownership of IP rights by companies and the economic performance of those companies. In terms of scope, the industry level studies were based only on EU level IP rights, so EU trademarks and registered community designs at our office, European patents registered at the EPO, and so on. But if you want to look at individual firm performance, then it's not enough to look at their ownership of EU level IP rights. You also have to look at their ownership of national level IP rights. For those of us listening from outside the European Union, it is perhaps important to mention that we have, when it comes to trademarks, design, and patents, we have a dual system in the EU. So a company that wants to register a trademark can choose to register it in just one or several countries, so you can go country by country, or it can come to the EUIPO and register a trademark that protects its brand in all 28 EU member states. So the two systems exist side by side. Depending on their marketing and business strategies, some companies choose to register national trademarks, other companies choose to register EU trademarks. But if you want to get an overall picture of the company's use of trademarks in this example, then you therefore have to look at both the national and the EU trademarks. And that's what we did in the firm level study, where we looked at trademarks, designs, and patents. Okay, we constructed a very large data set that basically merged three databases: the registers of the EUIPO and of the EPO, the European Patent Office, and the national IP rights registers of 12 member states. Why only 12 and not all 28? Because it simply proved to be too time-consuming to try to get data and match the data on all 28 member states. So therefore, we chose 12 member states to include the 5 biggest EU member states, and among the remaining 7, we made sure that we had a good representation of countries from the north, south, east, and west of the EU, and between them, those 12 member states account for something like 85% of the EU's economy. So we feel it's quite representative. This was by far, even though I only devote one slide to this was by far the most time-consuming part of the study, as is often the case. It's the unsexy job of getting the data together that often takes the longest time. So looking at some, the study has 2 parts. It has some descriptive statistics and it has some econometric analysis or statistical analysis, which I don't go into in this presentation, only insofar as to say that it confirms the result from the descriptive statistics. And therefore, I focus the presentation on the descriptive statistics because they are easier to explain and to understand. So, again, as I said before, we looked at whether firms that use or own IP rights, one of the 3 IP rights, whether they are different in some meaningful way to firms that do not own IP rights, and how does the use of IP rights depend on the characteristics of the company, what sector it's in, the size, the revenue per employee, the age of the firm, and other factors. So we looked first at number of employees, because that, of course, is one measure of the size of the firms. Overall, among the companies in our sample, which includes something like 130,000 companies in the end, the companies that did not own any of the 3 IP rights had on average 94 employees. On the other hand, among the companies that did own IP rights, the average employment size was 547. So companies that own IP rights tend to be something like 6 times as large as companies that do not own IP rights. And if you look at the individual IP rights, then you see that in particular the companies that own industrial designs tend to be big, more than 2,000 employees on average, as well as companies that own patents, which tend to have more than 1,500 employees on average. Trademark owning companies are closer to the overall average at 570. So that's already one fact that is established by this data, that companies that own IP rights tend to be bigger than companies that do not. We then wanted to look at some measure of financial performance, and here we chose to look at revenue per employee. We considered several other measures one can look at. Of course, when evaluating a company, you can look at profit, you can look at EBITDA, you can look at a number of financial measures. The problem with those measures is that because we're looking at companies from different countries with sometimes different accounting practices and different tax regimes, the definition of profit can be highly variable. We therefore chose to look at revenue because revenue is much less, the definition of revenue is much more harmonized among the countries, and it's also less subject to manipulation for tax reasons, for example. So this is our basic measure of, let's say, productivity that we use in this study. So again, we find that companies that own IP rights have higher revenue per employees than companies that don't. And specifically, that difference was overall was 28.6%. So companies that own at least one trademark or one design or one patent had on average 28.6% higher revenue per employee than companies that did not own any of the 3 IP rights. And that percentage was, in the case of patent, if you owned a patent, it was 25.7% higher. If you owned a trademark, it was 29.5% higher. If you owned a design, it was 31.4% higher. And in the report, we also calculate the percentages for companies that own a combination of those IP rights. But the bottom line is that this 28.6% figure. So so ownership of IP rights is associated with significantly higher revenue per employee. Again, I choose my words carefully. I do not necessarily say that the ownership of IP rights causes the revenue to be higher, but it is associated with revenue to be higher. And the econometric analysis that we did does provide at least a strong indication that that it is the relationship that the relationship goes from IP rights and the innovation that they reflect to the productivity and profitability of the company. We then looked at average wages, and again, comparing companies that owned one of the 3 IP rights with companies that did not. And here we again saw, not surprisingly, that companies that owned one of the 3 IP rights paid more than companies that did not, almost 20% more. And again, the percentage was highest for companies that owned a patent, 40.6%. Followed by companies that own designs at 23% and trademarks at just under 19%. Okay, which again is not a surprising result, because if a company has higher revenue per employee than another company, then one would also expect that it is able to pay higher wages than the company with the lower revenue per employee. So in a way, that is not a surprising finding, but it is nevertheless good to have it quantified. We were also particularly interested in looking at it, looking separately at large versus small and medium-sized companies, because in the European Union, there is, of course, most companies are small and medium-sized companies, and just for the benefit of those who may not be familiar with those definitions, small and SME, or small and medium-sized enterprise, is defined as a company with fewer than 250 employees, and an annual turnover of less than 50 million euros. That's the definition of an SME. So what we found is that overall in our sample, actually, only 10% of companies owned one of the IP rights, 3 IP rights in question, and if we look separately at large and small companies, then we find that only 9% of small companies, what you see in the upper right-hand part of this slide, that only 9% of the SMEs in the sample owned one of the 3 IP rights, compared to 40% of the larger companies. So in other words, ownership of IP rights among small and medium-sized companies is quite low, but on the other hand, and this is what we see on the next slide, oh sorry, I skipped this one. So this one shows the stock, so how many trademarks, design, and patents are owned by companies in each cohort. So you will of course not be surprising that not only does a higher proportion of large companies own IP rights, but among those that do own them, they tend to own more. So for example, an average large company in our sample owns 8.2 EU trademarks and 16.6 national trademarks, whereas for the small companies in the sample, the ownership averages are 2.5 EU trademarks and 3.4 national trademarks, and similarly for the other sizes. Okay, so if we are to look at the conclusions of this firm level study, then what we see is that that companies that own IP rights employ more people and pay them higher salaries. Those are the 2 bottom line findings of this study. And they have higher revenue per employee, and this difference, as shown in this chart, is particularly pronounced for small and medium-sized companies, because while the overall average is 28.6% or 29% in rounded figures, for the SMEs it is 32%. So this is the basic finding of this study, is that most small and medium-sized enterprises do not own any IP rights, but those that do perform better economically than those that don't. Okay, and as I indicate here, this relationship is confirmed by the econometric analysis, which is fully described in the report. Econometric analysis, unfortunately, is not something that's easy to put on a PowerPoint slide, so I have not included it here. But again, the conclusions there are the same as what I have presented to you here. Now, what is the logical conclusion of all this? It does not mean, of course, that we should go out and encourage every SME out there to go and register trademarks or designs or patents, as the case may be. Because, of course, many of those small companies that do not own IP rights do not own them because it does not make any sense for them to own them. I always use the example of the bakery. I have a dog. I walk my dog every morning, and usually I stop by a local bakery to buy the bread for breakfast during those dog walks. And of course, that bakery, it has intellectual property because it has a name. It has a skilled baker. They make very good bread. So it does have some intellectual property, but I'm pretty sure that they have not registered any trademark. There is no reason for them to do that. Okay? There is no particular benefit to a small business like that to register an IP right. Okay? However, it is also true that if there are small and medium-sized companies out there that could benefit from owning IP rights, but don't because they think that the system of registering an IP right is expensive or cumbersome or complex, and therefore they prefer to stay away from it, then it is our job as an IP office and the job of other IP registration offices around Europe and around the world to try to make access to our system of IP rights easier and cheaper for companies. And this is really the final message of this study, and I thank you very much for your attention. I don't know if there are any questions at this stage.
Maybe could you a little bit evolve on the research methodologies that were employed to come to these conclusions?
Yes. So basically, what we did is once we had the sample of companies, we ran a series of well, the descriptive statistics, of course, is obvious. You just calculate the respective averages for owners and versus non-owners of IP rights. In terms of the statistical analysis, we ran regressions where the dependent variable was the company's performance, i.e., mainly revenues per employee. In that example, on the other observable characteristics of the company that we had, such as which sector the company was in. We had a series of country dummies in there because, of course, wage levels are different among the different member states, so that had to be taken into account. We also and then we included variables for their ownership of the different IP rights. We also, again, this is all fully described in the report. We also included various lag specifications in the recognition that, of course, you know, if a company registers a patent, for example, acquires a patent, the effect of that on its performance may only be felt some years down the road. So we took all of those factors into account, and we also used methods. Fixed effects methods that are designed to some degree try to capture the fact that that there may be unobservable variables that cause the differences between the companies that we're seeing. This is always the danger in this kind of study, when that there may be some underlying factor which we have not captured that is causing both better economic performance of the company and the company being more innovative and therefore registering more IP rights. So, for example, if a company has superior management skills, then it could be that because of that superior management, the company is more innovative and therefore owns IP right and is more profitable. And in this case, it is the superior management skills that is causing both. So, but there are statistical methods that allow you to at least try to get at this issue. Okay, and of course we're talking social science here, so so that there is always some, you know, some uncertainty, some degree of probability that the relationship that you have uncovered may be a spurious one. But nevertheless, the results are quite robust.
Interesting. Well, thank you very, very much for this presentation.